Good morning, Your Honors. John Burton for the plaintiffs, and it is pronounced Chinarian.
Chinarian, thank you.
China Ryan is sort of easy to spell. I'd like to reserve as much time as I can for rebuttal.
How many minutes are you hoping to reserve?
5, I'm hoping.
All right.
So I'd like to cut to the chase here. With what I think is the applicable law that was not applied throughout the case. And it was established 27 years ago in this circuit, Washington versus Lambert. And bear with me if I could just read just a couple passages from that case. All people have a right to be free from the terrifying and humiliating experience of being pulled from their cars at gunpoint, handcuffed, or made to lie face down on the pavement when insufficient reason for such intrusive police conduct exists. The police may not employ such tactics every time they have an articulable basis for thinking that someone may be a suspect in a crime. So what we have here is a Terry stop based on reasonable suspicion that a car was stolen. It turns out the car was not stolen, because reasonable suspicion is something far less than probable cause. And when officers act on reasonable suspicion, the Fourth Amendment, according to this circuit, applies certain limitations on what they can do. And again, to read the applicable passage from Washington versus Lambert, which 27 years ago established the law on this. This is a quote: under ordinary circumstances, when the police have only reasonable suspicion to make an investigatory stop, drawing weapons and using handcuffs and other restraints will violate the Fourth Amendment. So,
Counsel, I think that's one of the key quotes in the law for the disposition of this case. And what I'm trying to figure out in thinking about the qualified immunity issue is, while that statement seems to be clearly established through Washington and then later Green, what is clearly established about when we're looking at ordinary circumstances versus when we're looking at non-ordinary circumstances? Because that's the line in that quote, right? Under ordinary circumstances, if all you have is reasonable suspicion, drawing weapons, using handcuffs violates the Fourth Amendment. So this ordinary circumstances qualifier seems to me to be the important thing that we're trying to figure out. Does this case match that, or does it not match that?
I think that's absolutely correct, Your Honor. I think we're right on the same point. And again, to turn to Washington versus Lambert, which itself rejected qualified immunity, as did Green for the officers. It says, despite the absence of a bright line rule, our cases make clear that we have only allowed the use of especially intrusive means of effecting a stop in special circumstances, such as, and then there are 4 listed.
So is your argument that that's a complete list, only those 4?
Well, I got taken for task on this. What I did was I directly quoted the court's order on summary judgment, and which is, these are the 4 that are listed in Washington versus Lambert. These are the 4 that are listed in Green versus City and County of San Francisco.
No, I get that, but what I'm asking is legally, are those the only 4? Because in the background here, we're always looking at a totality of the circumstances test. So is your position, is plaintiff's position, that the law really does clearly establish those are the only 4 circumstances that get you out of ordinary?
No, not at all. And in fact, that's why the court, when they're fashioning these rules, and I know Judge Thomas was on the Green panel, wrestled with this, want to make sure that police have at their disposal the necessary tools to protect themselves when engaged in investigatory stops. So if there's another special circumstance that's not on this list that could be articulated, then that could in fact allow these intrusive tactics on a Terry stop. But what do you have here? you have the fact that it was daytime, not nighttime, which, if anything, makes it safer. The second is that the windows were tinted. Well, tinted windows, especially on commercial limousines, are ubiquitous. But let's follow the logic of tinted windows as a special circumstance. The occupants of the car were ordered out of the car. They were 100% compliant. In fact, in terms of compliance,
Well, okay, so but the tinted windows, it seems to me, is the potential risk that the officers might face before they know whether they're going to have compliant people that they're dealing with or not, right? So that seems to me that's relevant because at the outset of this, they're looking at this kind of car. It's a big car, it could hold a lot of people. It's got tinted windows, no way to tell how many people are in there. So then the stop happens, and then at some point they realize there isn't 8 people in that car or whatever. But from the outset, we have no idea how many people are in that car. Isn't that something that officers are going to think about, and reasonably so?
absolutely. But let's follow the logic of this. The windows are tinted. They know there's 2 females in the front seat because officers Gonzalez and Menzies have seen that because they drove from the other direction before they did the U-turn. They, from positions of cover, like they're trained, they order the occupants out of the car. The occupants get out of the car. They don't at that point say, is there anybody else in the car? Now they are not blocked by the tinted windows. They're fully visible. At that point, Ms. Chinarian is made to lie in the street for 3.5 minutes, and the others who are fully visible are handcuffed. The officers clear the car and see there's no one else in it. There's no problem with that. The problem is what they did to these people after they complied and got out of the car.
But that's what I want to be really clear about your argument. Is that right? That you think the original stop and how they set this up and the plan that the sergeant formed in his mind before the stop occurs is all fine up until the moment that they know there aren't a bunch of people in that car, and then that's the moment that you think the Fourth Amendment violation happens?
I think that once they pointed guns at them, and once they had Ms. Chinarian lie in the street for 3.5 minutes, and once they put all 3 of these women in handcuffs, they violated the Fourth Amendment.
Okay,
The
so then
stop
answer to my question then
obviously
was no.
did not, because there was obviously this coincidence that a similar looking car that actually had a low jack device on it, which this one didn't and didn't activate, had been stolen before. And then there was this DMV error that no one could really anticipate. The license plate just had a 1-digit mistake. So the stop was valid. The LAPD, and this is really where I think this court, I would ask this court to look at this very closely. The LAPD has a stop, they call it an investigatory stop. And it was described by our expert, it's described in the brief. The officers have adequate resources. Here there were 13 officers and a helicopter. But you get adequate resources. The doors are ballistic. The officers can stand behind the door. They're free to take the guns out of their holster as long as they're pointed at the ground. They order the people out of the car. The people can hold their hands up. They can actually be directed to turn around to see whether they're armed or not. Then move away from the car. Then the officers can approach the car, which now has open doors, with their guns out and see is there somebody in the car who's not compliant, who's not coming out as ordered. All this can be done without the intrusive measures that were being used on these plaintiffs. Sergeant Cueto actually did not order all these things to happen. He just said, oh, I've got the possible stolen car, calls in a bunch of backup, and then they did this because this is what they do to everybody. That's why this went to trial, not on, I'm not here on a qualified immunity issue, although we've raised that.